Welcome to Module 13, Human Resources and School Operations, as part of 641 in the WSCAD program for Educate Wisconsin. Hello again, this is Chris Sadler, Director of Human Resources for the Sun Prairie Area School District. I've introduced other slideshows, so I won't go over my past here. You kind of know it, and I left some of the notes up there. But this slideshow is really important because educational philosophy is really about what you believe as a leader and how it plays out in your everyday work. And this quote by John F. Kennedy always kind of sits in the top of my head is that children are the world's most valuable resource and its best hope for the future. And that's really the baseline for my why, is that the kids we work with are truly going to carry our country, our communities forward. And that's why I place so much importance on being an educational leader. And that's why a lot of educational leaders do what we do. The first place we're going to start is investigating. The investigation process for any personnel issue you may come across. So just some of the first considerations you want to think about is you should have an established procedure for receiving and resolving complaints involving certain conduct. This can be used for both employee and student investigations. The school districts often also offer just a general compliant policy for complaints that do not satisfy the definition of discrimination, harassment, or bullying. Because the discrimination and harassment really does focus on specific protected groups. And there might be a procedure outside of that just to report an employee that has a complaint about a supervisor or a colleague or something else that's going on. So some of the guidelines you want to think about is any complaint procedure you have should identify a person or position responsible for investigating complaints. It should differentiate between the roles of administration staff and the Board of Education. Typically, the Board of Education only weighs in on these when it comes down to like a termination, non-renewal type of process. If there's discipline outside of that, like a suspension without pay or whatever it might be, that's really the role of the administrator or whoever might be the supervisor. They should provide easily accessible avenues for parents, students, employees, and others to pursue. It should be written in language easily understood by people outside of education or within education. And then it guarantees that complainants making good faith complaints will be protected against any retaliation. This is an important one to remind people about. The one thing that does become a little dicey once in a while is there are people that when they complain and then anything that happens after that, they feel like it's retaliation. And you just have to kind of continue to work through that the best you can. You should remind complainants of the need to be truthful and forthcoming concerning complaints. That's self-explanatory, but it still needs to be reminded that you have to report exactly what happened. I think the person meant this, or I feel the person. Those are just those are opinions. You want to have like truthful statements about what was happening. So the plan. First, you have to consider the seriousness of the allegations to understand what type of resources should be provided and timelines too. Does law enforcement play, if any, in the investigation? So the next part is establishing a timeline to complete the investigation. Try to get it done as soon as possible because that just helps with any type of decisions, especially if it turns out to be like something that's somebody gets terminated over. Sometimes you have to get the board involved because with teachers, anybody on contract, there actually has to be a board hearing where the board decides whether to terminate their contract because almost in all cases, the contract that a teacher's under or administrator's under is directly with the board, and the board has to decide at the end under the recommendation of whoever is investigating and the supervisor is. Don't rush to complete the job, even though you want it done timely, because if you rush and you miss a step, you could be spending more time down the line. Be prepared for unexpected delays. There are complex things that somebody forgets to say something or doesn't remember something but then does. It adds time. And then there are some policies that you'll have to pay attention to with deadlines. And then as we know, there are other deadlines as well, like non-renewals, which are coming up towards the end of April and middle of May. and any type of board meeting calendar that you can match that up to make sure you're hitting timelines that are important to policy or state law. So, continuing with the investigation plan, review documents that you have ready to access to review, including personnel files, any type of records, email, internet use. You may want to start, if you don't have a policy, you may want to, if you're investigating an employee or whatever it might be, you might want to shut down their technological, um, like platforms like Google, Outlook, whatever you might use as a district, because you don't want them getting in and deleting emails, which you can still find, but it just causes more time. Or taking files and hiding things like that. It's just important. And then the other part is really making sure employees know that that's happening, and it's really for their protection. In the end, you don't want them to feel like anybody's taking advantage of their files, and we want to make sure we just shut down those quickly. Think about payroll, time records, leave requests, any other records from law enforcement, social services entities that are important. If there's ability to take photographs based on whatever the situation is, those are important. Obviously, checking surveillance videos, where a lot of our schools and school district buildings are now videotaped in many areas, and those sometimes play a crucial role in finding out the actual truth. Any electronic records, like we've talked about, and then to start thinking about witnesses or people that would know about the situation that you would want to touch base with. So there's some investigation misconceptions. The first one, if it's not in writing, there is no duty to investigate. That's not true. That's just like mandatory reporting. If you hear something, just because it's not a formal request or complaint, that doesn't mean that you can just pass it off. If a complaint requests confidentiality, there is no duty to investigate. That's a huge misconception. Is if somebody tells you something in confidence, but you know it's a serious issue that has to be taken care of, you have to tell them up front, like, I would love to be able to say that I can keep this confidential, but what you just told me is so serious, I have to investigate that. If a complaint is withdrawn, there's no duty to investigate. That's not true either, because the complaint, again, might be serious enough that a person can't just say, never mind. You've heard it, so now you need to do something about it. If the third party is investigating the complaint, there's no duty to investigate. That's like if law enforcement takes over. That doesn't mean it's just now the responsibility has been released onto somebody else. That actually means that, okay, so now I have to work in tandem with whoever else is investigating this. I have to look at it from an employer side. Maybe they're looking at it more from a legal side. If the third party concludes that the complaint is unsubstantiated, there is no duty to investigate. Again, if let's say law enforcement is involved in the investigation, they're looking for a criminal aspect. You might be looking, on the other hand, against employee aspects of the handbook that aren't criminal, but they still could cause for some type of discipline within that employee. If there's no identified complainant, if the complainant is not, there is no duty to investigate. Again, it depends on the complaint, but if it's serious enough, even if it says anonymously complaining about something, you're still going to want to investigate it if it's against students, staff, whatever it might be, because if it's serious enough, you need to find out if it's real or not. If the investigator involved in the complaint occurred in the distance past, there is no duty to investigate. Again, that's not true. It all depends on the complaint itself. If it's serious enough, you need to dig back into it. If something comes down to one person's against another person's word, nothing can be done. That's not true. Again, you have to dig a little deeper, see if there's any other witnesses, if there's video surveillance of something, whatever it might be. You might go through all of that and still find out like there's no true evidence of anything. Then you can say my investigation is complete, but you can't just say, well, you think this, you think that, and I'm never going to be able to figure it out and walk away. One other misconception is an investigator may not consider or rely upon hearsay. That's not always true because a lot of the times people have seen enough, and you can get a preponderance of evidence, you would call it. It's kind of like teacher evaluation, a preponderance of evidence that could tell you, like, there's so much evidence in this direction. I believe that that's true. And then it's the same thing with circumstantial. They kind of go back together. The hearsay and circumstantial, again, if there's a preponderance of evidence that's showing you one direction, then you've got to take that direction. So, when you're thinking about interviewing anybody involved, the complainant, the perpetrator, and the witnesses, first identify the persons to be interviewed, including the alleged victim, if any. Determine others who may have firsthand knowledge. Ask each person interviewed if they know of anyone else who may have seen or heard what happened. That helps you kind of, again, dig deeper into the investigation. Prepare an outline of questions. It helps ensure a thorough and consistent line of questioning. If similarly situated witnesses are the subject of the same type of interview, you can compare and contrast the results from a standardized approach. That's just helpful when you're creating questions. Now, there are going to be times that you'll have to go off script a little bit, off your own script. Is that a question might pop up that you've heard somebody say something, you're like, wait a minute, that was new. I need to dig a little deeper into that, and that's okay. Interview each witness separately. Do not put them in the same room, or if you can avoid it, even just having them cross paths between before or after the interview. Now with Zoom, now you could do that without having them there, but I will say if you can do anything in person, that's really important to do because you can really read a lot of body language in those moments. Um, Advise witnesses to keep the information confidential until further notice and warn that retaliation is prohibited. That's just self explanatory, but sometimes people need reminded of that. And then create a record. Keep detailed notes, including the date and the time of the interview of each one. So now you're on to the questioning. So when you're thinking about questioning considerations, think about asking open-ended questions because it gives individuals a full opportunity to explain what they saw or what happened, and the opportunity to provide a complete response that addresses due process concerns. Because if we only ask certain questions that are very pinpointed, it doesn't allow the person being interviewed to really expound upon what they saw or heard or were part of, which can put a little damper on the due process process because in the end they need to be heard fully. The other thing that I've found out too is a lot of the times you're going to find out that open-ended questions can either talk somebody into being, I guess, exonerated, depending on which side they're on, or they can talk themselves in those open-ended questions in a way that helps you understand that maybe there is an issue here. So start with broad questions to become more focused. Allow the accused to answer each allegation in detail. Avoid leading questions. So those leading questions, if you're saying those again, you can have a due process complaint come out or a grievance saying that the questions you asked led a person to answer them the way they did. Ask repetitive questions. This is just as important as open-ended because repeating a question in a different way may verify the initial answer. It may reveal inconsistencies or provides the witness with the opportunity to give you more information if he or she was avoiding the first question. Periodically summarize and review what is said. So saying, so if I heard you correctly, this is what I heard, and then restating it, just to make sure that the person being interviewed again has a chance to review what you heard them say, and they can add or say, no, that's not exactly what I said. And then disclose to witnesses only what is necessary to question them. Because a lot of the times what you do with some questions is disclose that, oh, this is the complaint against me, and then they can start formulating ways to better answer the questions so they will not look like they made a mistake or were guilty of some employee issue against the handbook or policy. So continue to think about these other question considerations. Assess credibility. Watch eye contact, facial expressions, body language when individuals are answering questions. Obviously, this is not everything because everyone socially is going to be a little different, but it is very important to pay attention to because it may give you a clue about, oh, that question touched a nerve. I need to dig a little deeper there. Make note when you have an uncooperative witness. So just saying, this person avoided this question or outright refused to answer it. Use silence. Just like in the classroom, if you're teaching, people are uncomfortable with silence, and it may prompt a nervous witness to provide you with relevant information more or go deeper than what they were planning on going. And it's just like students, when you have that pause, it makes people talk more. And it can either bring out something that's like, oh, that's what I was looking for, or bring out something that's like, well, that sends me in this direction. If you think a witness is lying, use fact based questions to get back on track. Remind witnesses they are obligated to provide truthful information. You can do this at any point in saying, I'm going to ask a question right now that's very important in this investigation. I need you to be truthful, and then ask the question. View the area of the alleged incident just so you can ask questions that might be relevant. When appropriate, individuals demonstrate what occurred. So if they can, have them act it out or talk about what people said and how they said it. And then again, direct witnesses not to discuss the matter with others. Can you stop them from doing it? No. But it's really important that you say that because what will happen is if they go against your recommendation or your expectation, you can use this as well for discipline that is important to an investigation because it can cause a lot of issues between employees if they're talking about the investigation as they go. So interviewing the accused, this is a little different because the person probably is in a little bit different of a spot. I would do them last after you have obtained facts from all the other witnesses so you can use that to better gauge your own interview with them. Provide the accused with general background as to the nature of the allegations, just saying this is what is being said. Give a full opportunity for a response to each allegation. Direct the accused not to discuss the matter with others. Again, this is kind of for their own protection, is that you don't want anything to be seen as retaliatory. And if they're telling other people and they're giving their own opinion, that could turn some people to think that it's being retaliatory. If the employee is in a union represented position, the results of the question could subject the employee to disciplinary action. Determine whether representation must be offered or granted only if requested. If the investigation involves allegations of criminal misconduct, provide the employee with a Garrity warning, which again, we'll look at the Garrity warning in a little bit. So real quickly, this is copied right from the sample Garrity warning letter to have somebody sign if they're being interviewed. So basically, the main issue around Garrity warnings or Garrity kind of understanding is that the biggest part of it is there's 2 points, and one is that that during an interview, you're telling the person you're interviewing that nothing that they say can be used in any subsequent criminal proceeding. So what you're trying to do is you're just trying to figure out the employment issues that are involved with whatever you're investigating. If something is criminal and maybe being investigated from a third party like a law enforcement, anything this person says to you, you are saying that will not be used against them or be shared, basically. The other part is the 6th point of this is that if you refuse to answer questions related to the performance of your official duties, you will be subject to dismissal. So it's basically saying we will protect you from any criminal proceedings based on what you tell us. However, if you refuse to talk with us, even after giving this statement of rights, then we can dismiss you or terminate you. And basically what this is telling us, or you're telling the person being investigated, is that by you not saying anything, we are assuming guilt on whatever it is that you're investigating. So that's the basics of it. There are other points in here that are pretty simple that are similar to other warnings that you've talked about within here, like Weingarten, but really the basics around Garrity are the criminality piece, and then the other piece of saying that if you don't cooperate, we assume guilt and we can dismiss you because of that. So, employer rights. Cooperation. An employee who fails to cooperate or is dishonest during the district's investigation may be in violation of a board policy. They have a right to representation. They may not delay an interview by requesting the presence of a specific union representative when another representative is available. An employee has a right to representation where the employer reasonably believes that disciplinary action could result from a mandatory meeting with management. So there is Fifth Amendment protections. The Garrity right, which is Garrity right, is more about criminal activity, which again we'll talk about in a bit. The general rule, though, is when a public employee's conduct is in question, he or she can be compelled to testify about job performance and can be disciplined or discharged for refusing to respond. For searches and seizures, a privacy expectation must be met with both subjective and objective criteria. The employee must have an actual expectation of privacy, that the expectation must be one which society recognizes as reasonable. Um, this is going to be one of those pieces that is so variable if you're having to search or seize some type of property. Obviously, technology is one thing that is actually not the employee's property, that is the property of the district. So that's something that would be reasonable in confiscating or searching or seizing. Um, Personal objects, it depends. So, what I always recommend is as you're thinking about, do I seize or search this? Um, I would actually call legal counsel if at all possible in these cases because they're going to all be dependent on what you're actually looking for. So there is one document that's in your resources that's just the full investigation guidance document. That's more than just me talking. So feel free to take a look through that, and you can save it for future or for current issues that you might be going through. So now looking at harassment and discrimination, this is a whole other level of investigation that has to do with protected groups. So discrimination. I'm going to read it just because this is probably the clearest way of looking at it. Any unlawful action or practice, including bias, stereotyping, or student harassment, detrimental to a person or group of persons, and differentiates or distinguishes among persons, or which limits or denies a person or group of people opportunities, privileges, roles, or rewards based on any personal characteristics. And I'll talk about the descriptions in a minute. Behavior harassment is behavior toward or between students based on any personal characteristic described, which substantially interferes with a student's school performance or creates an intimidating, hostile, or offensive environment. Harassment can arise from a broad range of physical or verbal behavior that can include, but not limited to, physical or mental abuse, racial insults, ethnic or religious slurs, unwelcome sexual advances or touching, sexual comments or jokes, sexually explicit derogatory statements, or discriminating remarks that are offensive or objectionable to the recipient or which cause the recipient discomfort, humiliation, or which interfere with the recipient's academic or employment performance. So, basic information. Typically, an employee must submit a complaint of discrimination or harassment within 30 calendar days of when the incident of discrimination happened. During an investigation, it is very important to remind all involved regarding non retaliation. The district may have a specific timetable for investigations, so check your board policy. If the claims are brought to Equal Opportunity Employment Commission, you'll want to work with legal counsel. Typically, your district probably has an insurance company that works with a specific legal firm that would help you in this case, and help you probably investigate it as well. And then prepare for a long process. I personally have had one that lasted a year and a half, from the beginning of the investigation all the way till finally all appeals and everything were done. So before I do Weingarten rights, I do want to talk about protected classes within a discrimination harassment report. So basically, a protected class is age, if somebody's older, and that's 40 and above, race, ethnicity, gender, ability, religious beliefs, sexual orientation. When you're thinking about those protected classes, if the complaint does not base itself in those specific protected classes, your district should have another complaint process for employees to access if there is some other issue happening where it could just be employees treating each other poorly, but it's not really based on any of those protected classes. So just be thoughtful about that as you go through these processes. Weingarten rights. Weingarten rights guarantee an employee the right to union representation during an investigatory interview. The supervisor has no obligation to inform an employee that he or she is entitled to union representation. I will say best practice, I would just remind them, because then you don't have to get to that point where they're like saying, oh no, I want my representation. They asked for it right before the meeting, and then, scheduling, all of that kind of gets blown up. The one thing that I would say with this too is we've had issues where employees try to use Weingarten rights to not talk about a performance improvement plan. That's not the plan, because the plan really in the end, yes, there could be discipline at the end that could be non-renewal, but then the conversation itself is not disciplinary in nature. So they can have union representation there for sure, but they can't refuse to meet with their supervisor just because they don't want to talk about their performance improvement plan. It's kind of a tricky dance a bit, but that's just something to remember with Weingarten rights. So now we're going to talk a little bit about employee discipline. Let's just say you go through an investigatory process and there has to be some discipline attached to that. So you've established just cause. Um, Not every district uses just cause language or procedures, as it may be connected to tenure of some sort, but it still has a lot of merit to pay attention to, because no matter what, when you're thinking about just cause, it's really just good practice. So you want to make sure that the process has kind of been reduced to 7 categories. Is that the person has been given adequate warning for whatever the issue is, and saying, like, if this happens again, this type of discipline will happen. So it's not just a one off. Now, there are some egregious acts like abusing a child or whatever it might be, or hurting another employee physically. Obviously, there doesn't even be adequate warning for something like that. But there might be something like a person is late consistently and you've talked to them 2 or 3 times, and each time you say, if this happens again, this is the next step. That's what we're talking about. Reasonableness is just paying attention to the discipline itself, whatever the decision is does it fit the issue that's happening? So if somebody's late twice, I wouldn't say a 5 day no pay suspension is probably reasonable, uh, but something maybe a little less because you're thinking about how does this fit with whatever the issue is. You want to make sure investigation is complete, that the investigation is objective. There may be times where you actually look at a third party investigator. I know it costs more money. However, having a lawyer involved with some of the investigations that are maybe a higher level is a good thing because I think in the long run it will save you money not having to go back and forth with different investigations. You have proof of the infraction through the investigation and that your rules have been applied uniformly. And that goes kind of back to reasonableness, is most of the time you'll have another example of the same issue happening in the past. What was done then? How can you make it consistent with that? And then again, reasonableness of discipline. So this is just an example of handbook language from Janesville. That thing is pretty simple, and probably most of your handbooks will have the same. But it's handbook language, just basically focusing on discipline and how that might be handled through a representation of making sure that the meeting happens in a timely manner. And again, you want that language to kind of show that, yes, we're going to do our best to follow, making sure representation can be there, but not having it delayed too much, and to not stopping anybody that's a supervisor in the district from removing an employee from the workplace, because sometimes there is immediate action that needs to be taken. So other handbook language that have to do with disciplinary issues or materials that are placed in somebody's employee file. They can be provided to the employee before such material is placed in an employee's personnel file. Basically, what this is saying is before any type of letter goes into an employee file, they are given that copy so they know what's going in there. And this also allows them to reply or give a rebuttal to whatever the letter might say. It doesn't mean that discipline doesn't move forward. It doesn't even mean that the employee has some say in not having it happen. It's just giving them an opportunity to put a rebuttal in there for future reference. So what you want within a letter is pretty simple. You document the discussion, saying on this date at this time you talked with that employee and maybe representation. Writing a formal letter of reprimand, basically stating again what policy or handbook was portion was violated, what actually happened, and what are the next steps for discipline within that for that employee. There are some different levels of options here outside of just documenting the discussion and writing a letter of reprimand. If it's serious enough, they can have an administrative leave with pay. This typically is not a discipline. This is more used when investigating an employee issue prior to any judgment. It's giving the opportunity for that employee to be away from the situation so the district has time to actually provide investigation for that issue that might be happening. If there's a suspension without pay, this is more disciplinary, obviously. This length can be determined by issue. What I would do in any case is know that this act is clearly egregious and look for precedent. Has something like this happened in the past, and how was it handled to be consistent? Most suspensions without pay are typically 3 to 5 days at most. You don't want to go much further than that. If you go further than that, that seems to probably be on the level of termination or non-renewal. That's just kind of the gauge that I've used. And then there's termination. Now, termination, again, depending on the employee, if they're at will and hourly, they can be terminated that day and with just cause. From a contracted or certified employee like a teacher, it's a lot a higher bar for termination. Typically, what you have to do then is provide your evidence, provide your recommendation to the school board, and then at a school board meeting, that teacher or certified staff member can be provided with a closed or open hearing session where the board actually votes on their termination. So reprimand letter guidance. State what the letter is, very simply. This letter serves as a letter of reprimand based on, and then describe the issue and the dates and the times that it happened. Quickly review what happened or the action that is being disciplined. If you had a previous conversation with them, state that too, especially if it's a continued issue. It kind of provides evidence like this is not the first time that this has happened. Clearly state what happens if it happens again, saying, this is a letter of reprimand, but the next time this happens, it will be a suspension without pay or lead to termination or non-renewal. A summary statement, any failure to do so will result in further disciplinary action up to and possibly including termination of an employment. Signing the letter does not mean agreement, just that the conversation happened. And you can remind them of that and say, I need you to sign this letter so it shows that this conversation happened. If they still refuse to sign it, just write. Mrs. Smith refused to sign letter and date it. And you might even have their representation or your own representation just initial saying that other people saw you say this to them. And there's now looking at plans of improvement. So one thing that I want to talk about first, it's about feedback. The one thing about feedback is it's all part of a plan of improvement. So I want you to just watch a couple of the videos. There's the secret to be giving great feedback or feedback that's helpful. In the end, a plan of improvement is one big bundle of feedback. Your hope is that the person can grow through it, or it's great documentation for somebody that isn't improving. And I love the concept of Brene Brown saying to be clear is to be kind. In the end, it's hard to have some of these conversations, but if you're not clear, it's very unkind because the person doesn't really know your expectations. And actually that could be what fails a performance improvement plan, and not so much that the person failed during the plan. It was more about the communication failed. So the importance of it, proactive feedback, especially critical, allows for the plan improvement to be the next logical step. So if you have talked to this person clearly about concerns you have, and you've documented those just maybe in emails, that's a good step prior to a plan of improvement. You want to make sure your feedback is formative and growth-based, and evaluations should not be just focused on what is going wrong or as a gotcha and focused on growth, and more focused on growth. Refer to earlier sessions on feedback-related evaluations. Always talk back to them and say, hey, back on September 10th, this is what we talked about. Since then, I've seen this, this, and this happening, if it's improvement or not. Within that feedback, you have to be clear when practices are not meeting expectations consistently. Document conversations, discussions via email. Not everything has to be formal. It does not have to be a letter every single time that you have concerns. It can be an email because that's just as strong as a letter. And the evaluations need to reflect conversations to avoid the dance of lemons. What I mean by that is it's really easy to give everyone like very general positive feedback, but if you have concerns and that person goes over to another school or school district, they're going to take the same problems there. And in the end, all the kids we work with are everybody's kids. And we don't want to have that teacher moving from district to district every time their evaluation gets tough and they just decide to try to start over again. So this Dance of the Lemons connection there is just a video from a documentary that showed how teachers were moved from building to building where when they had performance concerns. If this ever moves towards discipline or non-renewal termination, you'll want this type of documentation to support the process. You want a very clear expectations that they were not meeting expectations. So best practice and professional improvement plans. Why? To improve the effectiveness of the teacher. When? It can be done anytime. After a verbal conversation about concerns typically, but there may be circumstances where it is immediately, depending on what you're seeing. How long? I would say no shorter than 9 weeks because it doesn't give them enough time to actually improve, but it doesn't also have to be the whole year. It's appropriate to reasonably reach the goals that are set, and in some situations, it could carry over from one year to the next. Those don't happen much because it kind of belabors the point, but it is something that's open. Who is responsible for writing the plan? Now, this is writing the plan. The supervisor. The employee can have input, but only input. They don't get to write it based on their own opinion. And then who's responsible for follow through on the plan? The employee. This is really important because a lot of the times employees in this situation will try to rope in the supervisor and say, well, you as a supervisor didn't do this for me. You didn't do this for me. This is about them, not you. You are saying, these are the concerns I have. This is a way I can support you. But in the end, it is your job to improve. So you can use regular check-ins and follow-throughs on support. However, the employee needs to be responsible for meeting the goals that are set and showing how they are meeting those goals. What questions need to be answered when writing a performance improvement plan? So, the what's. What guidance does the handbook give? Is there something in there that shows that? What do you want to focus on? Use your evaluation language to really focus you in on what your goals are or the job description. Focus on 3 areas at most needed for improvement. If you pick 12 or 15, it's too many for anybody to focus on. And then make sure the goals have clear action steps, easily connect to them. The one place that's difficult for this is looking at attitude and disposition. What I would highly recommend there is journal writing and having that employee say exactly how they did to connect with people in a positive way. Why? It might be clear to you, but it is clear to them. Why is the plan in place? Make sure they understand why. This is where documentation becomes so important if you go towards non-renewal. How? It's a very important step as it determines the actual path of the plan. How are actions observable? Is there a way that you can go into a classroom or into their work environment and see exactly how they're improving? Actions need to be easily documented. So when you see them, write them down. And they're easily seen by anyone. When? Timelines need to include regular check-ins determined by the administrator. Make sure they are able to be followed through on. This is really important. You can't meet in September and then not meet again until December and decide whether a person improved or not, because that is somewhat on the supervisor that you have to check in and provide them with feedback to understand if they're on the right path or not. And then who's going to be part of the collaboration? Who is responsible for what? There may be roles like mentors and things. They might not be brought into the performance improvement plan discussion, but the employee can know they can turn to them for support. And then again, make sure it's clear that the employee's responsibility is the improvement, not the supervisor's. Logistics, as you're moving through it, just review the plan with a human resources director or another administrator if you don't have a human resources person in your district. Just say, hey, I'm about to talk about an employee or talk with an employee about this. Can you just check to see if this is clear? When scheduling the meeting, be clear with the employee that the meeting is concerning performance concerns so they can prepare and bring representation if they'd like. When meeting, ensure everyone understands their role. The plan will be laid out and then the employee can ask questions. Don't allow them to ask questions as you go. I find that really slows down the whole process, especially if they're kind of arguing different pieces. If the representation is there, they are a note taker and listener, not an active participant. So they shouldn't be jumping in and arguing every point. They can ask some questions at the end if you feel like that's appropriate. But during the conversation, it's really between the supervisor and the employee. Again, the employee's signature does not show agreement to reasons behind the plan, only acknowledgement that the plan is in place. If they refuse to sign, just note that on the plan and schedule the next meeting to review the plan. And then send the signed performance improvement plan to the Director of Human Resources or another administrator. Could be your superintendent or assistant superintendent, whoever might be focused on that role. And then use the notes sections of the document to capture discussions of follow-up meetings. Or you can link your own document you share with the employee. This just helps, again, with the finalization of the plan. So if they complete the plan and they do really well, it's great documentation to show that. If you get to the end of the plan, it's just not improving and you need to go to non-renewal or some other way, you have that documentation too. So describe the process of the employee when the timeline is complete based on evidence already documented in check-ins. Provide a summary of whether the employee met the goals of the plan. Mark if the employee met the goals, met some of the goals, or met none of the goals. And then describe the next steps, which again could be non-renewal or some other direction. I have some plan templates on here for support staff, professional educators, administrator, and then I put a SWOT analysis in our resources. That's just a good resource for weekly or monthly reflection and meetings with employees. It kind of helps with the focus of, are these people moving in the right direction or not? So the non-renewal process versus termination process. We've talked a lot about this a few times, and I want to make sure that I cover them now. So human resources, when we're looking at non-renewal and termination process, always check school board policy and staff handbook language. The first two places to start. What does my specific district expect with it? There's performance-related non-renewal for teachers in their first years of service versus teachers with more than 2 years, sorry. And what I mean by this is that if you're within your probationary years in their first year or first 2 years, this allows for a little more flexibility with non-renewal and not as high of a bar of describing to the board exactly what your concerns are. However, again, you're always going to want to have the same process in place where you give feedback, most likely have a performance improvement plan, and then show whether or not the person has completed or have met the goals or not. There is also non-renewal for teachers for budgetary reasons. That's very different. As you know, our state law now says that there is no such thing really as layoffs. There might be layoff procedures, but in the end, it's a non-renewal for budgetary reasons. Then there's a non-renewal of administrators. An administrator, most of the time in some districts, will have a 2-year rolling contract, which means that there might be a year where the board or supervisor says, you know what, we're only going to renew you for the next year, and it's under a 1-year contract. And we'll talk again about the timelines of these different roles. And then there is termination, typically focused on egregious acts, physical issue, attendance, criminal activity, as it forces a high threshold of evidence and hearing before the school board for anybody that's a certified staff member. So here's some typical language again. Full-time teachers employed in the district are subject to non-renewal or on a statutory basis as described in the Wisconsin law. No full-time teacher shall be non-renewed for arbitrary or capricious reasons, which basically means that you just non-renew them for no reason. You don't have to have amazing evidence. It's a tough process to go through at times, but as long as it's not just because, it is allowable. Such non-renewal shall be exclusively subject to the provisions in Wisconsin laws and covered by the grievance procedure, because somebody can grieve and say, I don't agree with the non-renewal of my contract. Here's some more language: voluntary termination, which may include retirement, voluntary resignation, or non-renewal of contract. Which again, this is more of when somebody were to sign like a separation agreement in lieu of termination or non-renewal. So the non-renewal basics: school board approved preliminary non-renewal, delivered to the teacher no later than April 30th. A teacher can request a private conference with the board within 5 days of receiving the preliminary notice, and the final notice can not be sent later than May 15th. Budget enrollment can be a reason for non-renewal. Technically, only for full-time teachers is a non-renewal, and then can offer resignation in lieu of non-renewal. For administrator non-renewal, preliminary notice of non-renewal must be given at least 4 months prior to the end of a contract. Administrator can request a private conference with board within 7 days of receiving the preliminary notice of non-renewal, and then final notice no later than February 28th. There is a ASA guidance for both administrator and teacher non-renewal in your resources. Termination of employees. For certified employees, you have to maintain a much higher level of responsibility to show proof and reason, because this is breaking a contract in mid-contract. There's a hearing before the board to terminate the contract. This can become very public and very difficult for all. There is a myth that people can't be terminated within their contract, which isn't true. However, like I said, it's such a high level of responsibility. You have to document, and then communicate with the appropriate supervisors about steps being taken. You may want to think about a resignation agreement. The agreement can be a win-win, but you must balance ethics and ease. So what I mean by that is, let's say somebody has an egregious act, though it's kind of teetering on the fact of like, is the board going to approve this or not? And the employee might say, I don't want this to be public. And there might be a resignation agreement instead saying, you might agree to pay out their contract, but they have to leave physically and they're put on leave for the rest of their contract, something along those lines. Non-certified and hourly, at-will employee terminations allow for less responsibility to show reason. However, clearly articulating why is very important, because they could, again, grieve this or bring this to equal opportunity and provide and look for investigation through that. So document, and then communicate with supervisors about the steps being taken. Sorry about the length of that slideshow. I know it was huge, but there's a lot of information in there, and I know that you probably want to go even deeper, and some of our resources allow for that. So thank you. If you have any questions, please contact your instructor through discussion or by email.